Am I free to go?
I want my lawyer now.
I want a lawyer right now.
Mr. Nolan, it's for you. My name is Patrick Nolan. I'm an attorney licensed in the state of Missouri. This is Pat Talks Law. I frequently joke in an unfunny way that the criminal code can be broken down to just 3 offenses with varying degrees: crimes of meanness, crimes of stupidity, and crimes of poverty. But last night I was reminded of one of the major failings of our legal system, and frankly that's how we handle mental illness. Since before Ronald Reagan slashed funding for mental health in 1981, people suffering from mental health issues have resided in a gray area between treatment and criminal justice. Sometimes they get treatment and sometimes they get prison. Where you happen to be and the resources immediately available at the time of the budget year can make a big difference in whether or not you get treatment or you get prison. I was reminded of this when I saw Joker. Now, I'm pointedly not reviewing the movie. I don't think it's possible to watch that movie and not question your sanity just a little when leaving. And perhaps it hit me a little bit harder than some of the other movies because I had just closed a production of Agatha Christie's And Then There Were None, where I portrayed Justice Wargrave. So after having spent the previous 8 weeks channeling a psychotic break in the third act, that movie hit me pretty solidly. So let's talk about how mental illness affects the legal process. People who are experiencing a mental health crisis are far more likely to encounter law enforcement than to get medical help, according to the National Alliance on Mental Illness. As a result, according to the Bureau of Justice Statistics, 56% of state prisoners and 64% of all jail inmates have had mental health issues. Currently, 2,954 crisis intervention teams, that's where law enforcement collaborates with mental health services, operate in 46 states. 15 states have adopted Medicaid suspension policies while inmates are incarcerated. That means they don't get Medicaid for their medical treatment. At least 27 states and the District of Columbia have laws requiring officers to be trained to respond to mental health, substance use, and behavioral disorder issues. Laws specify which officers are to be trained, what entity is responsible for that training, whether or not there's funding, and whether or not the training is mandated. Now, I represented a guy whom the police were attempting to serve an eviction paper on. He was residing with his mother. He was suffering from mental illness and he fled from the police in his home and he retreated into his bedroom. In his room, he grabbed a gun and he pointed it at the police officers. And no, he is not dead, fortunately. Our municipal police officers in Kirksville have had training on dealing with people in mental health crises, and they handled that situation without gunfire. I truly can't say that I would have done the same if I was a police officer. As a criminal defense attorney, I'm only concerned with 3 major areas of mental health issues, and a 4th minor area but far more active. Now, we have all seen the movies and pop culture references to pleading insanity to get out of a crime. Number 1, not guilty by reason of insanity. You cannot be held criminally liable because you are not sane at the time of the offense, and you are unable to discern between right and wrong. Remember Edward Norton in Primal Fear? Now, movies aside, this defense is a loser. It fails 99% of the time, and on occasions where you are successful, your client goes to a secure mental health facility for years instead of prison. A defense attorney will look for almost any other defense before relying upon this one. A second and far more common issue is arguing that the defendant is incompetent to stand trial. In Missouri, that is Chapter 552. Every state has their own statutes and code and evaluations, but the essence is the same for all of them. The defendant, because of their mental condition, is unable to comprehend the trial and unable to assist in their defense. The proceedings are stayed and the defendant is sent to a secure mental health facility until they are again competent to stand trial. And this could take years. No attorney willingly goes down this road for minor offenses. But if your client is not competent, you have an obligation to seek an evaluation. I have worked with one client that was not competent. It was a scary situation. And I had a couple that were borderline. I had to have them evaluated. Now, the third major area is not used frequently, but it's diminished capacity. This is the defense we use when you're arguing that your client is not NGRI, but because of their mental health concerns, they are not as culpable as a reasonable person is, or a healthy person. This is where we would argue for a lesser offense or lesser time for sentencing. For example, yes, my client did it, but he didn't commit murder in the first. Rather, he committed involuntary manslaughter. However, not every crime has a diminished capacity component, if you will, that's available to argue. Now, the fourth minor area is where most of the work happens. So minor is misleading. Defense attorneys and prosecutors come together and they work. Some defendants are required to have evaluations. Defendants have diagnoses of bipolar, schizophrenia, PTSD, and other mental health issues. But they don't have money for their medications, and they don't have funding for treatment and counseling. When they're arrested and they're put in jail, they are prescribed medications for their conditions. They receive those meds while they are in custody. But when they're released and they're back out on the street, off probation, they run out of their meds, or their drugs are stolen or traded for a place to stay, and they stop taking them. Then the voices start coming back. The anger returns, and the spontaneous outbursts or inappropriate behaviors return, and they soon get arrested again. And then the defense attorney is again talking to the prosecutor, who also knows that the defendant is getting back on their medication in jail. As long as they have those meds, the defendant is not a danger to anyone. And the process begins again until it ends. And it will end with an overdose or a serious crime that results in prison time. The mentally ill are thrown back into the criminal justice system again and again and again. And that's because police and courts have to deal with these issues. However, all of society would be better served if instead we spent that money on treatment before getting to law enforcement stage. A shrink is much cheaper than a criminal prosecution, and there are no victims. There is another slashing of mental health budgets in progress. President Trump's proposed 2020 budget calls for a reduction in the Substance Abuse and Mental Health Services Administration. That reduction is $62 million. That is a cut that will make it that much harder to get people the help they need. It makes it far more likely that a person suffering from a mental health crisis will spend time in prison instead of a therapist's office. Please do not read these comments as an endorsement or rejection of either party. Either party could make sure mental health issues are fully funded, but neither party is willing to do so. That trickles down to the states as well. Sadly, it's much easier to get funding for a prison and for police armored vehicles than it is to provide mental health counselors and necessary drugs. At least 50% of my criminal defense cases have a mental health component to them. A lot of family law cases do as well. Thank you for watching. Please hit like and subscribe. Smash the alert button so you know when our next video comes up.